Evening to all. It is a great pleasure to introduce our first webinar on Migration Gender Talks, where we will debate important subjects related to these specific migrations. I would like to introduce Professor Eduardo Figueiredo from Coimbra Law School and Leiria Polytechnic Institute, Professor Nausica Palazzo from NOVA Law School, Professor Emellin de Oliveira from Leiria Polytechnic Institute, as well as Executive Coordinator of the NOVA Refugee Legal Clinic, and Professor Garrido from Portuguese University and team leader of the line of research on migration, gender, and sexuality. So I will now give the floor to Professor Eduardo Figueiredo.
Okay, thanks so much. First of all, I would like to thank Professor Rui Garrido, team leader of this research line, for inviting me to participate in this event. And of course, my dear colleague and friend, Emellin de Oliveira, which is doing a wonderful job in the refugee clinic. And of course, the work you do is absolutely wonderful. So congratulations for that. I'm going to share my experience as a constitutionalist on the topic that we will discuss today. And I want to start by saying that for a long period, migrations and migrants, they were somehow ignored by the constitutional texts in Europe. In the Portuguese case, only in the Constitution of 1911, it was recognized to foreigners the same rights that were recognized to Portuguese citizens. Some exceptions were then established, namely in what relates with political and public rights, whose recognition was dependent on the compliance with the principle of reciprocity, and this was introduced in the Constitution of 1933 and maintained in our Constitution, which is dated from 1976. Nowadays, our Constitution clearly recognizes foreigners and stateless persons the same dignity of national citizens. Remember that Hannah Arendt defined human dignity as a right to have rights, which means that there are some basic rights and freedoms that must be recognized to every human being and fully respected independently of their citizenship or lack of connection to a specific state. Another principle that I find really important in this matter is the so-called principle of universality. It is established in Article 12, number 1 of our Constitution, which states that every citizen enjoys the right and is subject to the duties enshrined in the Constitution. Of course, the interpretation of this precept might raise some doubts, namely on how the term citizen must be comprehended and interpreted. Nevertheless, Article 15 of our Constitution solves our doubts, establishing that foreigners and stateless persons who find themselves or who reside in Portugal enjoy the same rights and are subject to the same duties as Portuguese citizens. These precepts solve our doubts, as I told you, in this matter, and allow us to safely state that Portuguese citizens, foreigners, and stateless persons are holders of the same rights and freedoms, with some exceptions that are then consecrated in the article or even in the law, as long as those restrictions comply with international law of human rights and the regional documents concerning this topic. Another fundamental principle that I find it really interesting to consider is the principle of equality, and namely the principle of non-discrimination. Article 13, number 2 states that no one must be privileged, favored, prejudiced, deprived of any right, or exempt from any duty for reasons, for example, of sex, race, language, territory of origin, or sexual orientation. As you can see, nationality is protected because the two main criteria to attribute nationality, they are established in this article, and I'm referring to jus soli and jus sanguinis. Also, sexual orientation is mentioned. Sex is also mentioned, although a reference must be made to gender and not to sex. And of course, gender identity is not mentioned, but we have to consider that this list, it is not a rigid or a taxing clause. In fact, there are other criteria that justify the mobilization of the principle of non-discrimination, as it's the case of gender identity or disability. We must consider, however, that this principle does not impede the existence of what we can call differentiated treatments, as long as those treatments are justified by serious and reasonable reasons. This is particularly relevant in the case of women and people with a different sexual orientation and gender identity in need of international protection, especially considering their particularly vulnerable status caused by what we can call intersectionality. In this case, not only special efforts must be taken in order to avoid that these persons can be discriminated when compared to others, but also specific measures should be adopted to provide them with favorable conditions to exercise their rights and liberties in an equal basis with others. In other words, measures that are able to guarantee equal opportunities to all. At this point, I also want to stress that our Constitution not only prohibits any discriminatory treatment towards people with different sexual orientation, and this means a non-heterosexual orientation, or a different gender identity, and this means a non-cisgender identity. In fact, our Constitution also recognizes that the right to relate and the right to express and live in accordance to a specific gender identity are clear manifestations of the rights to personal identity and development of personality, personal basic rights protected under Article 26, number 1 of the Constitution, and that can only be restricted under really specific and concrete situations, which are expressly mentioned in Articles 18, numbers 2 and number 3. I also wanted to state, and I also wanted to stress that the right of asylum is also foreseen in our Constitution. And this is really a wonderful conquer of our Constitution, and it somehow shows how our Portuguese constitutional text opened his doors to the international community and to the idea of fraternity between individuals and between cultures. This article, I'm speaking of Article 33, number 8, states that the right of asylum is guaranteed to foreigners and stateless persons who are objects or are under grave threat or persecution as a result of their actions in favor of democracy, social and national liberation, peace among peoples, freedom, or the rights of the human person. And we have to note that Article 16, number 2, which states basically that the constitutional and legal precepts concerning fundamental rights must be interpreted and complete in harmony with the Universal Declaration of Human Rights, somehow opens the door to the principle of the highest level of protection, which means that in case of conflict between a national and an international norm, the precept that confers a higher protection to the human person and human dignity is the one that must prevail. One might ask, which is the general content of this right of asylum under the Portuguese Constitution? And we can say that it has essentially two different dimensions. The first one is the right to be hosted in the national territory and to be provided with favorable conditions to live with dignity. For example, recognition of access to the education and health system, basic resources to live with dignity, and mechanisms of family reunification. On the other hand, this right of asylum is intimately connected to the principle of non-refoulement. Nevertheless, there are certain aspects that must be considered in this context. The first one is that the right of asylum foreseen in our Constitution must not be understood as a privilege of those who manage to reach the Portuguese territory, and must also be invoked to those who find themselves, albeit temporarily, subject to Portuguese jurisdiction. And this is because in many cases, it is really hard for people to reach the territory of the state that confer them asylum. Also, and the second aspect I would like to stress is that considering our Article 7, number 6, the Portuguese state must be entrusted with specific obligations with regard to reception of persons in need of international protection arriving on the territory of any of the European Union member states. Also, we must remember that this right of asylum requires the existence of a procedure for the person in need of international protection to request it, as well as to challenge in court any unfavorable decision regarding it. In this case, a due process must be assured, as well as each and every procedural guarantee that are ensured in the constitutional text. This right of asylum is then concretized, is then densified and strengthened by the Portuguese law of asylum. In the case of women and people with different sexual orientation and gender identity, they can be protected as members of a specific social group. And this law defines a specific social group as a group that shares an innate characteristic or common history that cannot be changed, or share a characteristic or belief considered so fundamental to the identity or conscience of the members of the group that they cannot be required to renounce it. And this group has a distinct identity in the country in question because it is seen as different by society that surrounds it. It is wonderful to say that nowadays there are no doubts that people with different sexual orientation and gender identity, they can request the statute of refugee based on the fact that they are being persecuted as a member of a specific social group. But this was not clear some years ago. Also, I would like just to stress the importance of subsidiary protection, because of course it is really important, namely in terms of people that are forced to displace themselves in reason or because of conflicts and because of war. So you've been hearing me talk about the Portuguese Constitution, the Portuguese law, and how it confers protection to people that are forced to migrate and that are in need of international protection, especially when they have a especially vulnerable position, as it's the case of women and people with different sexual orientation and gender identity. The question is why there are so many people that still fight to find a safe place in the world to live, to be, and to love. Why there are so many human rights violations since the moment that the person is able to leave his or her country and the moment that he or her is conferred the statute of refugee. I can say that this is probably one of the biggest contradictions of modern times, because law in the books is so far away from the law in action that it is almost impossible to believe that these norms truly exist and that they can be seen and read by everyone. At the end of the day, I can say that the problem is that law is a social construct created by humans and applied by humans. So every kind of perverse social differences and wrong social perceptions of what it means to be different, they are directly translated into norms, into administrative decisions, or even into judicial decisions. And this somehow makes me also, leads me to another question, and I will end with this. When I think of people who are different, people who need to leave their houses, who need to leave their homes because they are being persecuted for who they are and for who they love. And the more I read about globalization, mondialization, tolerance, inclusion, the only question that comes to my mind is, how can anyone be considered a foreigner in their own planet Earth? Thanks so much.
Thank you so much for your intervention, Professor Eduardo, and I'm sure that those questions will be in our mind for a long time. It's interesting the way that you put your message out there, and I think that we should reflect on that message too. Thank you so much. I will now give the floor to Professor Nausica Palazzo, please.
Thank you, Tanya. Thank you, Rui, Emellin. I also join Eduardo in saying that you're doing an excellent job. I really hope that I can attend also more sessions, let's say, in the future. So I'll be quick. I gave let's say, a short overview about special vulnerabilities that are created by the war. So, of course, wars create extreme suffering and vulnerabilities across populations, meaning across social groups. But there are some groups that seems like they're experiencing very special forms of vulnerability. And I would start with trans persons because it seems like they are technically allowed to cross borders, but even when they have transitioned from women to men, so from a gender as women to men, vice versa, when they have transitioned from men to women, but soldiers at the borders are preventing them from crossing the border because they are considered as biologically a male. And you know that there's martial laws in the country that apply that prevent all persons from the age of 18 to the age of 16 from leaving the country because they want to make sure that they have enough military forces so that men are not leaving the country. So we have two vulnerable populations within the trans community, both the persons that are technically allowed to leave the country because they have completed the gender reassignment procedure, so they are legally recognized as women, but nevertheless the soldiers, so the law in action, as we were saying, the practice, the application of the law is not still of course, sufficient, and the soldiers are preventing them from crossing. And we have a second form of vulnerability, which is that of trans persons who have not completed the gender reassignment procedure because it's only been introduced in 2017. So you know that these procedures are very lengthy and cumbersome also in other Western countries. So they require constant psychological assessments, they require hormone therapies. And in the case of Ukraine, there's also very long bureaucratic procedures. So most of the people don't have completed, most trans persons have not completed the procedure at all. So they don't have any document to show that they should be able to leave the country because they have a different gender. So this is a first set of very special vulnerability. A second set, I would say, regards more generally the LGBTQ population. You might know that Russia is not very LGBTQ friendly as a state. LGBTQ movements have been silenced, shut down, very, very harshly and violently. So there are LGBTQ activists, but they suffer from persecution. So this is obviously something that will be transposed to Ukraine should Russia become, sovereign within parts of the territory of Ukraine. And this poses extreme dangers to the LGBTQ populations because we've seen that in the last few years, Russia has become extremely harsh towards this population. I'm thinking about the propaganda law, the anti-gay propaganda law, which is a law that it's extremely vague, that prevents basically all forms of discussion. We're talking about discussion of LGBTQ rights. So even creating a banner, even creating a flyer, even discussing in a public space LGBTQ rights, and has been, of course, used by the government to crack down on opponents who are sensitive to LGBTQ topics, to all sorts of persons that want to even talk about LGBTQ rights. And I want to push this one step further because actually we've seen something much more dangerous, I would say, from our perspective, which is what Patriarch Kirill said in the aftermath of the outburst of the war. So a few days after, the Patriarch of Moscow said that this war is actually justified because we have to fight Pride marches, because Pride marches are a manifestation of sin on earth. So we could discard this statement as something weird, fringe, but it's actually not. It's actually an increasing tendency of the church in Russia, the Orthodox Church in Russia, in adopting this kind of eschatological approach in which it asks, what's the ultimate meaning of life? What is the ultimate meaning of the church on this earth? And this ultimate meaning, it seems like it's the destruction of LGBTQ population. So we're talking about something that is extremely harsh, and that's been also becoming pervasive within the population, because cultural values, religious values are much more important within Russian society than in our society. So I wouldn't discard this statement, but I would take them very seriously because they can lead to something even more even more destructive, even more worrying, that goes even beyond our imagination, okay? So I would say that LGBTQ persons are definitely a second set of vulnerable persons. A third set of vulnerable persons, I would say, are surrogate mothers. So you might have known, you might have heard that Ukraine is a pretty big surrogacy hub because especially after a few years ago, they closed India, Thailand as a avenue for performing surrogacy for foreign couples. Then these, let's say, surrogacy tourism, I don't want to use this term in a bad sense, but literally surrogacy access has shifted to Ukraine, which now has extremely high demand, but also extremely high supply of surrogate mothers. And I think that wars creates vulnerabilities for these mothers as well, for these surrogates as well, because there are some ethical dilemmas if you think about how much can we ask in these surrogacy agreements to these women, because sometimes they have very strict requirements. They have a very specific diet, they have a very specific requirement of living not that far from the clinic. And I think that these ethical dilemmas are becoming more harsh, more evident in the case of war, because they're being asked sometimes to leave the country and leave their own family behind, right? Because they had to put the kid in a safe place where he could be born and where the intended parents could pick him up. Or sometimes they have been asked to stay in Ukraine and give birth at the border at their own risk, because if they cross border, for instance, in Moldova or Poland, you know that these countries do not allow surrogacy, so they would not, they would recognize the biological mother as the legal mother with all the consequences that you can imagine for the intended parents. So I think that surrogacy also gives us pause for thought, because it's kind of bringing to the fore this question of how much should we ask to the surrogate, even in these cases where they're putting their own life at risk or they're forced to leave their families behind because, for instance, the husband cannot leave because there's martial law. The last phenomenon that I want to mention is the phenomenon of women that have to perform abortions because sometimes they have been raped. And of course, this is extremely problematic. And there was an article that I wish I didn't read on an Italian newspaper about women going to Poland, who cross border to Poland, because, you know, most of them go to Poland and are not legally allowed to get an abortion, because the new law in Poland basically allows abortion only in the case of rape, but only if the woman gets a criminal conviction. So only if a magistrate ascertains that she has been raped. And, you know, this is an impossible proof for them, because we have soldiers without a name that rape these women, and there's no way we're gonna have within the 12 weeks that it's the limit to, within which they can get an abortion, a decision of the court that ascertains this situation. So now we have a tragedy within the tragedy, which is that of women who cannot abort a child, which is the product of a rape, because they are situated in a country that further discriminates them because doesn't let them get an abortion. I very much look forward to discussing these topics with you. Thank you.
Thank you so much for your intervention, Professor Nausica. I think that I'm speaking in the name of all the people here and all the people that are listening to us. It's definitely like a reason for concern what is happening between Ukraine and Russia, for all the reasons that you presented here, but specifically in this case about women and their position, their situation right now in the middle of this war. Probably, like in the general speaking, probably it's not the focus of governments right now, but it's definitely a very vulnerable situation for them. Thank you so much for your intervention. I will now give the floor to Professor Emellin de Oliveira.
Thank you very much, Tanya. Thank you very much, Rui, and all the members of the Migration, Sexuality, and Gender group. So it's really a pleasure to be here and discuss with the two outstanding scholars that you have here, Professor Nausica and Professor Eduardo, such an important and interesting topic. So thank you very much for this initiative. I would not take that much time, and what I would like to propose right now is just making a kind of sum up of the ideas that were already presented and link them to migration law, migration studies in general. So at first, I think that it's important to mention the Geneva 1951 Geneva Convention. As you know, it's the convention that expressly told us who is the person called refugee. And actually, what you had in 1951 Geneva Convention and in its 1967 protocol relating to the status of a refugee is that you have a person that cannot or does not want to come back to her or his country of origin because there is a well-founded fear of persecution based on the race, religion, nationality, political opinion, and this particular social group. And I think this is important to call the attention to it because actually, as you can see in the Geneva Convention, you don't have specifically the protection regarding gender, the protection regarding sexual orientation or gender identity or expression, for example. But as you know, there is persecution based on it. And actually, there was a kind of development in the law in general, international and European law specifically, in order to try to include those people in this protection. And you can see already this, for example, in the qualification directive, the European Union qualification directive in 2004, that was already repealed for the 2011 directive, that included directly in the idea of membership of a particular social group, gender orientation, gender identity, and gender expression. So those people could be included in the qualification directive and could be included in order to be recognized as refugee or beneficiaries of subsidiary protection. But not only in the European Union, you also have, for example, in 2010, the recommendation of the Council of Europe also included the sexual orientation, gender identity, and gender expression as the possibility of recognize people as refugees in the member states. And all of those legislation, if you can say, not the recommendation because it's not binding one, but the idea is having as based of these ideas the Yogyakarta principles from 2006 and the Yogyakarta plus 10 in 2010, which is this document that outlined a set of international principles in order to guarantee human rights to sexual based in relation to sexual orientation, gender identity, gender expression, and sexual characteristics, which I think it's really important. But again, it's a non-binding document, but that was used as a guideline for all those legislation that I told you already. And what I think also that's important to mention is because in this kind of definition of who is or who is not the refugee, we have this idea of the proof in order to show the states that the person has the well-founded fear. And what is this well-founded fear? And how you can prove this well-founded fear when you are talking about membership of a particular social group. At first, there was for a long time a discussion if we could include or not women and LGBTI people in this kind of social particular group. And actually, we have here the guidelines on international protection, the UNHCR guidelines number 9 from 23rd October 2012, that actually expressly informed the states that they could include LGBTQI people in this idea of a member of a particular social group. Because the idea that you have behind this is the way that the persecutor sees the person. So the idea is the discrimination, the way that they think they are superior. All those people have to follow a kind of values or ethical behaviors. So the idea is taking the place of the persecutor, and the persecutor saw those people as one single group. So in that case, you can protect them as one single group. So here you have this kind of guidelines in order to simulate and contribute for an interpretation of who is the refugee, and a refugee who is based on a membership of a particular social group. But regarding also the persecution, it's quite interesting also to see this in order to make a kind of general analysis of the types of protections that LGBTQI people, but also women, can have. At first, the idea of discrimination. So the direct discrimination, that it can be expressly seen in, for example, criminal legislation, when you have directly criminalization of same-sex marriage or same-sex relations in general. So in that case, people who can prove that have or want to have same-sex relations and come from countries which expressly criminalize those kind of relations could be included in this protection. But when the person does not come from a country who expressly criminalize, then you have a kind of issue. How that person can prove this inclusion, this membership in this particular social group. And then you have the issues regarding the proof. So, and you have a lot of case law based on that. So some countries that started to use some questionable ways to make people proving they belong to this LGBTQI community. I'm sorry using community, but just to generalize and going straight to the point. So, for example, using kind of porno videos and make the people show they are attracted to this kind of things in order to prove they belong to this specific social group. But not only that, also the use of lie detectors when they are expressing and saying the facts in order to prove that they belong to this specific social group. But in this way, it's already difficult to prove. But now imagine when you have a person that does not belong to this social specific group, to this group that is called LGBTQI people, but is persecuted because his community thinks she or he belongs to this group. So actually, in general idea, immigration studies, the persecutor, the person does not have to have the ideas or the characteristics of the persecutor thinks she has or he has, but the person must be persecuted because the persecutor thinks that she belongs to this group. But if it's already difficult to prove that you belong, try to imagine to prove that you do not belong, but you are persecuted because of it. So then you have that even if you have a kind of development in the general legislation in order to include LGBTQI people in the international protection regarding his or her sexual orientation, gender identity, or gender expression, then you have the procedure. And in the procedure, you can find some obstacles in order to achieve this kind of protection. And just to add a new idea and finish with it, because I don't want to take my time from you, and I think that the discussion it's an important moment in this webinar. So I would like just to call your attention to the Ukrainian situation. So as we all know now, since the 2001 Temporary Protection Directive has never been activated, and this was the first time that you have activated this directive. It's important to see the difference that you have in the things that were already seen and foreseen in the directive regarding the decision, the council decision of this year. So what I would like really to call your attention, the 2001 Temporary Directive also recognized the right of family reunification for the people who receives this temporary protection. However, this directive at the time, 2001, just foreseen as family members in order to be reunited, of course, underage children at all, but the spouses. So you can reunite your spouse. Only this. The directive did not express anything related, for example, with partners. But in this year, in 4th March this year, 2022, Council implemented decision. Actually, in this Council implemented decision, the partners, the unmarried partners, were included as family members, and they can be reunited in the situation, in the Ukrainian situation regarding the temporary protection. However, this can be done only where the legislation or practice of the member states concerned treats unmarried people in a same way or comparable way to married couples. And then you have already another issue, which is, as you know, not all states allow same-sex marriage or recognize same-sex couples. So how could you protect couples who are already couples, but they are not married, or even the state, the member state where they go, do not accept the same-sex relations. So actually, we activated a directive including rights that in practice you cannot implement it because you still have some kind of discriminatory way in these member states that forbidden or you even create obstacles to access these rights. So I would like just to call your attention and maybe just join some ideas for the discussion. And once again, thank you very much for the invitation, and thank you very much for being part today in this such an important, interesting discussion. Thank you.
Thank you so much, Professor Emellin, for your intervention and for all the information that you have shared with us. I will give the floor now to Professor Rui Garrido.
Thank you, Tanya. Thank you, everyone, for your excellent contributions to this discussion. It's quite difficult for me to close this panel. At least to share. I want to share some ideas and trying to wrap up some of your discussions. And I will start to look just to the issue of Ukraine from inside, and pick some things that, for example, Nausica mentioned the issue of the rape of women and the abortion, the provision of abortion when they reach Poland. And something I cross in my research is the invisible rape, or the rape of men. And we don't have any kind of data on this issue in Ukraine, but I'm certain that we are going to find it sooner, because this is a more and more tactic of war that armed forces use to legitimize their action and to try to demoralize civilians and resistance. So we never, and this particular violence against men, it does not have to be related with their sexual orientation or gender identity. So it's quite difficult to qualify it as a rape, because when we have some kind of report of this kind of situation, it's usually the authorities qualify it as torture and not exactly as rape in context of war. So this is very, very it's a very unstable soil for us to look, because when we think about violence and violence against sexual orientation, what I think, for example, in case of conflict, it's international humanitarian law. And in international humanitarian law, we only have distinction between civilians and armed forces or military. But even international humanitarian law, this grants some kind of protection to what they understand as vulnerable groups, such as women, children, and the elder people. And it's very difficult not to think that LGBTI people are in particular vulnerability in case of armed conflict, not just because they are ordinarily discriminated in peacetime, and during an armed conflict, this kind of discrimination is very amplified. So this relation between international humanitarian law and, as Emellin said, the developments in international human rights law that we already know from the recent developments in international law, that they are not suspended. So these developments granting some protection to sexual orientation and gender identity must be observed even during an armed conflict. So because international humanitarian laws still have these blind spots, they don't look at distinctive, or what Eduardo said, the intersectionality of the civilians. Civilians are not all equal, and we can recall the issue of Syria and the persecution of LGBTI people by ISIS group. They were identified as different, and they were punished by that just because they were LGBTI people or understood as such. Another thing I want to talk about is about something that Nausica has said, the speech of the Patriarch of Moscow, and the clash of civilizations that we are witnessing, and how European, or what we understand as European values of tolerance, inclusion, are at risk with this conflict. Because if European Union does not understand this as a resistance against human dignity, as Eduardo said, this is very, very, very dangerous for the project of the European Union as well. Because I might remind you that there is in Ukraine some Chechen troops. And if you recall the news in 2016-17, the president of Chechnya, Ramzan Kadyrov, just not to say it wrong, started a purge against LGBT in Chechnya. And this should ring bells that what might be happening in Ukraine against LGBTI people. So we don't have the news, but we have the spotlights that show us what might be happening, and we are not seeing, because information is not exactly we need verification of the information, and sometimes between refugees and people forced migrations, well, LGBT are usually the invisible migrants. And just to give another issue, on this particular aspect of violence during armed conflicts and against LGBT, and catching something that Emily said, the principles of Yogyakarta, and the newer version of the principles of 2017. They granted a new principle that it's the right to truth. People have the right to truth, to know what happened to them itself if they survive, or in case of that, the family has the right to know what exactly happened to that person in particular. We are talking about violence against people based on sexual orientation, gender identity, and sexual characteristics. Because this is something that we are going to think or need to think in the future. That is, we need a reparation process after this conflict. We need to ensure that society is going to be able to heal after this violence, because it's something that we need to think about. Russia is doing an aggression against Ukraine, and when Russia retreats, eventually, what's going to happen inside Ukraine, and linguistic dynamics between Ukrainians and Russian speakers. So this is one of the issue, and another issue is, what about the violence against LGBTI people during the conflict? Those who still in the country and those who are abroad in Europe or elsewhere because they needed to flee in order to survive. This is another issue that I'm going to leave it to debate. And finally, the last thing I want to mention is something that Nausica pointed very well, the issue of transgender women that are not allowed to leave the country. We don't have this kind of issue for trans men, for example, but we don't know exactly if they wanted to stay because they understand them as men and they want to fight, what is exactly the response of the authorities? Because they might be identified biological as women, but they identify themselves as men. So men, they want to fight. So what exactly is happening with this? Because we just have information about trans women that are being identified as biological men, and they are not being able to allow it. And even when the Ukrainian law recognizes their right to change their gender. So I leave this final words to debate, and I think that I covered the majority of the issues that we discussed here. Thank you.
I was mute. Thank you so much, Professor Hui, for your intervention. Now I will probably open the debate. I would like to ask if someone has questions that would like to address to someone here in the panel.
Well, I was waiting for Rafaela, but I will start the debate. First, I would like to say that everything that you said is extremely important, especially in the context that we are now dealing with the situation in Ukraine. One thing that calls particular attention to me was the question about women in Poland that are being raped, and my question might be what can be immediately done, because as Professor Nausica said, we cannot wait for a decision of a criminal lawsuit in those 12 weeks. And we do not have some kind of unlawfulness exclusion clause for these women to abort. So the answer, in the meanwhile, what should be this answer, or what can we do in order to respond to this situation.
I would take this question very quickly because there are associations, there are NGOs that are aware of the situation, that are providing illegal abortion services in Poland. For instance, Abortion Without Borders is an association that's been very active in providing the pill for these women to get an abortion without waiting for a useless trial that will not allow them anyway to get a conviction in time before the 12 weeks to get an abortion. So luckily there are associations there that are helping these women. The point is whether these women know about it. So whether they have access, they have the resources to reach out to these NGOs, but they're doing a pretty good job, a very good job. Yeah.
Thank you, Professor Nausica. Does someone would like to? Any other questions?
If not, I have a question. So I don't know if anyone has a question, but I will just briefly doing some to ask something to Emellin. That actually Eduardo mentioned it as well, so you are free to comment as well. The UNHCR International Protection Guidelines number 9 on asylum, based on asylum claims based on sexual orientation, gender identity, says that there is no need to LGBT people to be recognized as a social group. They might be persecuted based on religion, and as Professor Nausica very well expressed an example of the patriarchy of Moscow, said, well, this war is legitimized because we need to fight this sin, and the LGBTI people are sinful, and it's a morality issue. So we have this kind of religious speech, not only in Russia, but also in Africa, a context that I know very well. And also, it might be as also recognized as persecution based on political opinions. If we understand that, for example, for Russia and their propaganda law, for example, LGBTI people are not understood as, or they are understood as a political issue. So I would like to know your opinion about this, and in particular for Eduardo, I would like to know if Portuguese law mentions something about this. Thank you.
Thank you very much, Rui, for your question. Actually, the idea is to not make at first the difference between who is LGBTQI a person in regarding to a cis person. So the idea is the reasons that that can make someone to flee and try to find international protections are the same, because we are people, so the things can happen to anyone. However, as happens to women, we know that there are some reasons, some motivations for persecution that are based on this simple and single way of a person being a woman, or because a person is a LGBTQI person. So actually, it's important to see the both situations. You can be persecuted because your religion or the religion of the country or the community that you are inserted does not accept the fact of you are an unmarried woman, or if you're having sexual relations out of a marriage, or because you just are attracted to a person of the same sex of you. So actually here, I prefer to see these kind of persecution based on the membership of the person, because this is a specific a specific kind of persecution. It's not because of the religion in general, because this is a kind of value created for a person, for a community that can be changed. So actually, and even for political opinion, it's not a kind and only of political opinion, because criminalize, for example, same-sex relations. Of course, it's a thing that can be started in a political level, entered into the law. However, as we know, the law, it's a kind of an expression of the general society ideas, and the law can be changed as soon as the society changes its ideas. So I do think that it's important to start to create specific protections. Unfortunately, I do not believe that open the Geneva Convention now in order to add specific protections would be a good time to do it, because as you know, the world and the political ideas are changing now. But if you can protect people, women and LGBTQI people, but not only them, specific minority groups, based on the memberships to a specific group, I do think that you have to do it, because this is also recognized that a person can be persecuted because of a specific discrimination and a specific value, idea, whatever you want to call it, that is created to differentiate someone, and not only differentiate someone, to justify persecution. So I do think that it's important to make this differentiation. Of course, you still have many countries trying to resist, and they are not open to this idea. They still prefer to protect based on political opinion or religion or whatever they want to just use as motivation. Of course, this is important because the most important thing here is to protect them. However, I also do think that, of course, as an academic way of thinking, that the representativity, that we know that those people were persecuted because they are who they are, in order also to create all the ways to protect them and not another solution to those kind of issues. Thank you.
Yeah, thank you. I will also comment as well. Thanks so much, Emellin, for these wonderful inputs. Well, I just want to say that in many cases, people with a different sexual orientation and gender identity, they have to bring up with different justifications in order to get the status of a refugee, because they cannot prove that they are being persecuted because of their sexual orientation or gender identity. So they will have to say, yes, I'm being persecuted because of my religion, because of my political positions, etc., etc. Of course, this is not the desirable solution. I can say that this is probably what happens in 99% of the cases, at least here in Portugal. I don't really have knowledge of any cases of people that were being granted or attributed the status of refugee because of their being persecuted in cases or in because of their sexual orientation or gender identity. But I just wanted to say that I think there's a lot of work to be done, not properly in terms of the law, but essentially in terms of the procedure, because many of the prejudices, they are, of course, expressed by those who are called to apply the law. Because as I've told you, our Constitution, it protects all these persons. Our law, it establishes that this person, they can be considered as a specific social group. But then you have to prove the persecution. And I can tell you that either you live in a country where you will be killed if you are homosexual or if you are a trans person, and you can somehow prove that this country is persecuting you, or it will be really hard for you to do this kind of proof in front of the authorities of another state, even if it's a state like Portugal, where the rights of LGBTQ people are somehow respected. And I can tell you that, for example, in many cases, the persecution, it is not pursued by the state. It can be pursued by the community. For example, you can't live in that country because the prejudice is so deep that you are constantly exposed and vulnerable to violence. And of course, they can say, well, you can just change your city. You can go to another city, you can go to another place of the country, but you never know if the way people look to sexual orientation and gender identity is violent in every place of that country. So it is really hard to show that you can't live there because of who you love and because who you are. And of course, Emellin talked about it. Sometimes it's really hard to prove that you have a specific sexual orientation. And I can tell you that in many cases, there is a clear violation of people's rights to intimacy because they are obliged to share every detail of their intimate and private life with authorities. And that's something that clearly violates fundamental and human rights and human dignity of these persons. So I can tell you that probably the biggest problem in this question is how the prejudice still continues to forge the minds of those who are called to apply the law. And they somehow look to people who get out of their countries because of their sexual orientation or gender identity as people that want to be opportunistic, that wants to come to a new country to get the status of refugee, but they don't really have the need to do so. And that's because you don't recognize the importance of having this right to relate and this right to live in accordance to your gender identity. So I really think that in the national terms, most of the work, it has to be done in terms of education and in terms of more and more information to authorities about this topic and about how they have to deal with these persons that ask for the status of refugee because of their sexual orientation and gender identity. Not only the status must be recognized in some cases, of course, but also all the procedure must be absolutely in compliance and respectful to their rights, to their freedoms, because as I told you, the principle of universality says that no matter your nationality, no matter if you're a stateless person, you still have your fundamental rights. So they have to be guaranteed in every moment. The moment you start a procedure until the moment you end it, and after the moment you end it. Thank you so much.
Thank you so much to all. It was lovely to spend this time with you. We had amazing interventions. I'm sure that we will keep all the information that we got from this webinar with us. It was very useful. I wish you a good evening to all, and one more time, thank you. Thank you for joining us.
Thank you.
Thank you, everyone. Thank you so much.